Okay, I think we'll get started. Welcome to the business session of the Planning Commission for October 5th, 2022. And first of all, we'd like to acknowledge we have a forum here today and welcome our visitors both online and those that are present here. First of all, are there any ex parte communications or conflicts that disclosed by any members of the?
I have none.
So hearing none, we have a couple of business items to take care of, but before we do that, we try to provide an opportunity for general public comments. And we have any general public comments that we're aware of. I haven't received any sheets. Assuming that we do not. So we will move right into our business items. We have two business items today, project CUP-22-011, a public hearing and possible action on a request by Catherine Pasker on behalf of Robert Bryan for a wall height extension to construct an 8-foot wall along the northwest property line at 7275 South Caladora Cove. And item 3.2, project ZTA-22-003. A public hearing and possible action on a city-initiated ordinance amendment related to the commercial use requirements in the mixed use or MU zone. So we'll turn the time over to staff to present on the first business item. Byrne, excuse me. Thank you, Mr. Byrne.
Thank you, Commission. I'll start with the conditional use permit for the wall height extension. We did go over this in the work session. I'll just go through this presentation again quickly. This is a request for a wall height extension at 7275 South Caladora Cove. A portion of the wall exceeds 8 feet in height. Any portion of a fence or wall or combination that exceeds 6 feet in height does require special conditional use approval. So that's what's in front of you tonight. The fence is already constructed. There's a comprehensive background and summary of the context of why it's constructed without approval. That's found in the staff report. I'll refer to that rather than go through that in full detail. But due to previous enforcement measures and appeal measures, the city is required to accept this application retroactively and process it as we would a new application. So that's what we're doing. Staff has also, on this slide, we've measured the entire constructed fence, and it does not exceed 8 feet at any point. This is a picture of the fence on the subject property that's been constructed. As you can see, it extends off of away from the side of the house and along the side yard. It's an open enclosure that encloses a concrete dog run landscaped area. And then the property slopes down from front to backyard. So a large portion of the fence does not exceed 6 feet, is fully compliant with city code. And then as the property slopes down, it does exceed 6 feet and requires that conditional use approval. Here's a summary slide of the background, which is again analyzed in more detail in the staff report dated 10/5/22. And then relevant ordinances for this request, 19.76 is the chapter of the city ordinance that regulates fences and walls. It allows fences and walls in side and rear yards to be built up to 6 feet without any approval, up to 8 feet with obviously above 6 and up to 8 with conditional use permit and building permit, and then above 8 and up to 12 with conditional use, building permit, and signed neighbor consent. The middle one is what's under consideration tonight. So it requires conditional use, requires building permit, but no neighbor's consent. Fence per city ordinance is defined as a barrier of any material or combination of materials erected to enclose, screen, or separate areas. Staff has analyzed what's been constructed and finds that it does comply with the definition of fence per the ordinance. So we are processing it as a fence. And then fence height is measured from the adjacent existing natural grade at the base or fence of the wall to the top edge of the fence of the wall. So wherever that fence is on the property, it's measured from the natural ground to the highest point. That's different than how we measure structures, where we take averages of the various points of the structure. There's no averages here. It's just bottom to top. And then there are two required criteria for wall height extensions as the city considers these. One is the existence of unique or special circumstances of a natural, material, and adverse nature relating to the property will be substantially minimized or eliminated by the increased height of the requested fence. And two, that the erection of such fence is the most reasonable solution under the circumstances. The rationale provided by the applicant to satisfy those two criteria are to provide families, pets with unassisted access to the backyard, to screen utilities that serve the home, to mitigate noise to and from neighboring properties, and then to provide increased privacy. Staff also did an analysis. There's an estimate in the staff report, and we've actually went through and counted these in detail today. Since 2019, there have been 15 applications for wall height extensions. I say approximately there because one or two may have been withdrawn and not gone through. But in any case, the ones that have gone through have all been approved, and privacy is used as a valid rationale in all of those cases, or at least a vast majority of those cases, and found to be a reasonable satisfaction of the ordinance criteria. Staff is tonight recommending that you take public comment, and where we have another meeting in 2 weeks, come back and deliberate and make a decision at that meeting. Two public comments have been received and forwarded to the commission, one from the applicant, one from an adjacent neighbor whose property line kind of shares this fence. But the recommendation in the staff report is to approve this conditional use request with two recommended conditions. One, that a building permit be obtained and inspections be completed. However, that needs to happen with the fence being built already. And that the permit be submitted to the city within 30 days of planning commission approval to make sure it happens. And then two, that the fence not be enclosed with a roof and basically converted into a structure. A structure there would not comply with city setbacks, whereas a fence does. So that is another recommended condition. That's all I have for this one. Are there any questions from the commission?
I do have a question.
Sure.
I guess the thought occurred to me, is there a precedent for a penalty or a fine for building without a permit in the city code?
It's code enforcement action, which is a citation process, which generally I don't manage the code enforcement division, so we just kind of defer to them. But generally what they do is they'll issue a notice of violation and begin the citation process, which down the line over time, if the violation persists, may end up in court. Generally, though, the court will look at how to cure the situation. In this case, code enforcement found that, hey, one of the valid options to cure the situation is to go get your permit. One of the appeals that happened with this project was kind of along those lines of there was an open violation of a fence constructed over 6 feet without approvals. Initially, city staff refused to accept a conditional use application. The decision not to accept that application was appealed, and the city's appeals officer said, no, you have to accept the application. So there were steps. We were kind of thinking along those same lines, saying you have to see through the code enforcement process first before we can consider this. But the appeals officer said the city didn't have authority not to process this as we would had it not been constructed yet.
And I do understand that as the genesis of where we're at, but fundamentally as a commission, we're looking to provide the guide rails for the future of the city. And the idea of there being I'll just ask for forgiveness later. I mean, I don't know. It's a simple matter.
Yeah.
We obviously have some recommendations from staff that resolve this issue. I was just, if there isn't a something on the books or a precedent, it
would be that code enforcement criminal citation process. And in this case, the police department has recommended, hey, if there's a way in the code to resolve this, we need to explore that before we proceed with any further citation process.
Commissioner Chapel, I will add on a case-by-case basis, the code enforcement department will sometimes use financial citations. But I think it just depends on the situation.
Okay.
So I think they have the leeway to do that when needed, which could be a helpful tool to kind of discourage.
Thank you.
I mean, just adding on to Commissioner Chapel's comments. I mean, the whole beg for forgiveness thing just bothers me a little bit. Just in terms of I understand that ultimately it's not supposed to be a penal situation, or we're not supposed to punish, and we just apply the rules fairly without it being arbitrary and capricious. But in this case, when they went through the process, they clearly knew what the process was, and then they rescinded the application and built it anyways. It gives me pause.
Yeah, fair. I would just remind you, the purview of the commission is the land use authority. Code enforcement can deal with
100%.
that and the frustration, associated with that, but that should not factor into any decision made.
I 100% agree, and I've been reading the code to see if there was anything there, but we get to vote on what's in the title, and that's about it.
I know the applicant is here, so you can hear from them as well if you'd like.
Any other questions for staff at this time?
No.
Okay. We will give a moment to the applicant as well, if you would like.
Good evening, members of the commission. My name is Catherine Pasker. I'm an attorney from Parr Brown Gee and Lovelace, and I'm here on behalf of the applicant, Robert and Ashley Byrne. They're the owners of 7275 Calidora Cove. We've already submitted our comment. We hope you've had a chance to go through that because we think it provides some additional important context on this situation. We can appreciate the Planning Commission's frustration with the wall having been built already, but as somewhat alluded to by Mr. Johnson, that there is a basis in the code for confusion about how to measure the height of the fence. Structures are measured based on an average height. That is what Mr. Byrne understand would be acceptable in this situation. But once he got in touch with me, in touch with council, we've initiated voluntarily without any direction from the city, or you do this or you're gonna be punished. We proactively went to file a new application to get this done properly. As Mr. Johnson alluded, the city does have tools to pursue enforcement. It chose not to in this case until later, as I discussed in my comments. I think wisely, because the point of city enforcement is to encourage compliance. And in this case, that wasn't necessary. The applicant went and tried to become in compliance, and that is what he's trying to do now. We have submitted our comments in response to, I believe, some others that have been submitted by the neighbor that have concerns with setbacks and whether this is a structure and things of that nature. We think we've addressed those issues, but are happy to respond to any others and to any questions that you may have.
Questions for the
Great. Thank you very much for your time.
Commissioner Ebler? Any questions?
No, I mean, I read the neighbors' comments, and I empathize greatly with them. It just seems that a lot of it kind of relates more to like Chapter 8 and under problems and nuisances in terms of the dog barking issue, and it's really just a code issue. I don't think it's anything that we even get to consider.
Okay, thank you. Okay, any additional discussion?
No, it seems pretty straightforward.
Yeah, I would agree. And with it not being kind of within our purview from a code enforcement standpoint, I would actually move to approve the project.
We can pause. for
We technically should open the
the
public hearing.
public hearing
Oh,
tonight as well.
Perfect.
I don't see a huge crowd, but
And just, any further discussion? Well, then we should hear public comment first. Any public comments, on this item? And I'm not sure if we have anybody in the, we do have a hand raised. Mr. Fielding, you're being promoted and
Thank you.
welcome.
Thank you.
And
Can you
just
hear me
a
now?
Matter of clarification, Mr. Fielding, you will have 3 minutes to make your comment.
Okay. My name is Kyle Fielding. I'm a lawyer representing the neighbors, Mr. Vamsi, Giganti and his wife. We submitted our written comments. Well, he submitted his written comments along with a letter written by my law partner, Dan McDonald. That letter explains that technically this is a building structure, not a fence. It's a technical reading. So respectfully, we disagree with staff interpretation on that point. Interestingly, Ms. Pasker even noted that originally her own client measured this as a structure, not a fence. So there's definitely some ambiguity there. But Mr. Yagani and his wife just want to be good neighbors, but they are quite negatively impacted by this dog run. They have a bedroom window just next to the dog run, and the barking noises have significantly increased, despite the application's suggestion that the heightened materials will mitigate the barking noises. And the wall has sort of an enclosing and tunneling effect on the Yaganti's driveway. The pictures don't really do it justice, but the property line is just 2 feet from that wall. So it's very tight. And apparently, I don't know if it's out of spite or what, but the applicant has recently started storing all of his garbage cans in that 2-foot space between the wall and Mr. Yagani's driveway. So it's right there next to their driveway and basketball hoop the garbage cans are facing. But anyway, the application does not actually meet the very high burden of proof that's required here. And that's clear and convincing evidence. So one of the requirements, as noted by staff, is that there exist unique or special circumstances of a natural, material, and adverse nature that are minimized or eliminated. In other words, a natural problem on the property that's solved by the placement of the fence. The application provides 4 rationale that could literally be applicable to any house in this neighborhood. They're not special or unique to this particular property. And staff mentioned that privacy has been used as justification. Well, if in a lot of applications, if that's true, if privacy is so common, then by definition, it's not unique or special. In reality, this application is an application for where to put the dog run, and the homeowner chose where to put that dog run. It's a conscious human decision, not a natural circumstance on the property. And putting that dog run right next to the neighbor's bedroom window is not the most reasonable solution. So criteria number 2 fails as well. The most reasonable solution is put it in the backyard. There's a very large backyard that's away from the neighbors, not as close as possible to the neighbors. There's also mentioned the application of privacy, security, and utility screening as justifications. The utilities really aren't a problem, and privacy and security are pretty questionable when this wall only runs a very small perimeter of the entire property boundary. There was one security issue that my client's aware of, but they came from the backyard fence, not this side fence. So respectfully, Mr. Yagani and his wife do object to the conditional use permit being issued. They are negatively impacted here. They would like to see it torn down since it was built without permission and in violation of city code. And if the conditional use permit is issued, they'll likely challenge it in the manner available under law. But we thank you for your time and consideration.
Thank you, Mr. Fielding. Let's see if we have any additional public comment.
Commissioner Mills, do you want a motion to close public comment?
I think we can, let's consider this. There may be some advantages to keeping public comment open on this item. Because we definitely have some strong feelings are being expressed here. I have a feeling that if we allow the respective attorneys to continue to comment that there will not be a backstop to this discussion. And so I believe that we have the information in front of us from the 2 immediate parties, but I am anxious for us to make sure that the others in that vicinity that may be affected have the opportunity. So I might entertain a motion to continue to keep public comment open on this item and give us a couple of weeks to make sure that any other individuals and interested parties might have an opportunity to comment as well.
I move to keep public comment open until is it October 19th?
October 19th is the next date of the planning commission's meeting.
Yeah, so I move to keep public comment open until October 19th and move to a date certain.
We have a motion. We have a second.
Second it.
We have a motion and a second. Any further discussion on the motion? I'm going to assume you're ready to vote on the motion. All those in favor of the motion to keep public comment, do you have staff seems to have a burning comment here.
I was just gonna say if you'll roll call it instead of asking all in favor.
Okay,
Thank you.
go ahead. We'll roll call the motion to keep the public comments period open until date certain. Commissioner Ebler,
Aye.
Commissioner Anderson, sorry,
Yes.
the chair's blood sugar is a little low here today.
Aye.
Commissioner Chapel, yes.
And Commissioner Mills, yes. The motion is continued.
Commissioner Mills, would you entertain a motion to postpone consideration of the item until the meeting on a date certain October 19th as well?
Repeat the motion.
My motion would be to postpone consideration of the item until a date certain October 19th.
To postpone consideration. Because we're keeping the public comments period open, I think that's presumed in the motion. Is there a correction from staff on that? Is my presumption correct?
I think it's fine. We're clarifying now, and I think it's inherent in continuing public comment that you're not going to make a decision and then take public comment on something that's been decided on. I think we're good.
Thank you, Commissioner Ebler. I always appreciate somebody that likes to get nerdy about Robert's Rules of Order with me. So thank you for having my back.
No worries.
Okay, we'll move on to the next business item, project ZTA -22-003. A public hearing and possible action on a city initiated ordinance amendment related to the commercial use requirements in the mixed use zone.
Thanks again, Commission. I'm not going to spend a ton of time because we did get good direction in the work session and this will come back. I would just recommend we can leave this has been noticed for public hearing, so we can leave the hearing open, but staff won't be ready until the November meeting to continue the discussion. So I'm going to go through very quickly here. Try to keep it under a couple minutes. Staff has been directed by the City Council to pursue a text amendment to the mixed use code requiring ground level commercial, and that the direction was that general. So that's what we've taken a shot at here. I think the desire is to avoid mixed use projects that are predominantly residential at the ground level. I will also note that the general plan that's in progress right now, the update, will include a new mixed use development ordinance kind of at the end of it that is completely overhauled. So this text amendment will be a temporary measure that's in place until that time, sometime next year. So I will just share what's in the existing ordinance and what's proposed, and then open it up for discussion and public comment if there is any. But right now in the mixed use ordinance, it defines a mixed use building as a single building containing more than one type of land use or a development with more than one building and use somewhere on the development. So they don't have to be combined. Examples of this, as written today, are the Union Lofts project on Fort Union Boulevard. There's actually two projects right in that vicinity where those are predominantly residential. The ground floor, even though it says office, is live work, and it doesn't have to be work. It can be just residential space. It's kind of flexible space. I think there were some concerns by the council, probably spurred by these, where they wanted to see that a little more commercial oriented on the ground floor. We've got other examples though too. This is an example of both vertical and horizontal mixed use on 1300 East. Storage building with a print shop, and then next to it is a veterinary hospital. This would comply under ordinance. And then another example of horizontal and commercial mixed use. There's no residential here, but office buildings and credit union in close proximity. What's being proposed are requirements that would require or mandate that commercial uses be developed in any mixed use project and occupy at least 70% of the width of ground floor of buildings along a project street frontage, and then a depth of 40 feet. There's additional language in here as well that clarifies what live work units have to be, including they have to be open and accessible to parking areas or the public right of way or main access roads. They have to be used, they have to be designed, constructed, and used as a commercial space. So it's not flex, it's a required commercial use. Any part of those live work units that are used for residential parking or storage don't count towards the 70% requirement. The first story must be at least 12 feet in height. We have some notes on how to clarify that, and we'll do that. And then parking must meet all the minimum parking standards of the city ordinance. So this is an attempt to mandate ground floor commercial without mandating vertical mixed use in every case, which would mandate more building height even when it's not necessarily desired by developers. But this just makes sure that the ground level of mixed use projects remains commercial, especially along main access roads or street frontage. And then based on the notes in the work session, we'll come back with some ideas for how to address some of the concerns that were raised by the commission there. Any questions on this? Thank you.
Thank you, staff. And we anticipate that we will hear more from you. Do we need to take action on this today?
It's scheduled for public hearing, so go ahead and open that, and then I would just recommend you can continue the public hearing, and then I think that's all we need to do.
Okay, I'm anticipating that we'll hear more from you in November.
November,
So,
yeah.
good. Well, first of all, let's just open any comments, public comments on this project? I'm not seeing any in the queue as well. Okay, so let's maybe we'll a motion to keep the public comment open and to continue the project.
I'll make that motion to keep public comment period open. And therefore the project as well. Until November. November 2nd, thanks. Until November 2nd meeting.
I'll second the motion.
I have a motion and a second. Any additional conversation? Okay. Commissioner Ebler.
Aye.
Let's see.
Commissioner Anderson, yes.
Commissioner Steinman
Yes.
and Commissioner Chapel.
Yes.
Commissioner Mills, yes. We have one final item to take care of. Well, two items, but the approval of the minutes, the Planning Commission minutes from September 7th, 2022. I'm going to presume that the commissioners have had a chance to review those, and are there any edits to those minutes that need to be made before we have a motion?
No.
Move to
Seeing
accept the
none.
minutes.
Are you ready? Did you make the motion, Commissioner Ebler?
I did.
We have a motion,
Second,
a motion and a second, and I think we can go with the voice vote on this. All those in favor of approving the minutes from September 7th, 2022, say aye.
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 Any opposed? One last item of business.
I motion to adjourn.
second,
A motion and a second. All those in favor?
Aye.
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 Aye. Any opposed? We are adjourned. Thank you, everyone.
Thanks, staff. Thanks, commissioners.
Thank you.